This is sort of on a case-by-case basis. It's one of those lawyer weasel answers. It depends. It depends on who the creditor is and what the facts of the case are. In a Chapter 7, of course, debts just go away. So on the one hand, a creditor might say, well, the creditor's got nothing. Doesn't sound like you're a good risk. On the other hand, as I said earlier, well, you can't do another Chapter 7 for 8 years and a day, so you're not going to be able to discharge those future debts, and you've freed up future income to pay on those future debts, so perhaps a creditor views Chapter 7 quite favorably, as opposed to Chapter 13, where you're going to be in that plan for several years, and the creditor doesn't know for sure, are you going to finish the plan? Generally, in my cases, my clients do finish their plans. I've only had 2 Chapter 13s where the debtors simply did not finish their plans. Unfortunate, but that's the way it was. They had an adverse change of circumstances. But from a creditor's perspective, that creditor doesn't know for sure if you're going to finish the 13. So it may sort of distance itself for a little while. I've noticed it's usually about a year before they will approach you to see if you want to borrow money or obtain credit. So it's sort of on a case-by-case basis. You take a look at the Chapter 13. If you've got a high percentage plan, that's going to look more favorably as far as a creditor is concerned, or more favorable as far as a creditor is concerned. If it's a low percentage plan, maybe less so. And again, it's going to depend on who the creditor is and who at the creditor's office is reviewing whatever application you've submitted.